Here is the reply brief to the state of Minnesota in the United States Supreme Court on the EUC case where they deprived Minnesotans of their federal unemployment compensation benefits in 2010 and artificially suppressed the state's unemployment rate, so that eventually that program has disappeared entirely from the state of Minnesota. I'm going to read from it if you're interested. This is a very well organized reply to a response by the state of Minnesota. It's got a very well organized table of contents here. I'm just going to read through it. You might find it illuminating as to how the state can run a federal program and arbitrarily and unconstitutionally deprive so many thousands of people of their benefits, including myself, and get away with it. So here's how they do it. However, one thing that's happened, as I've already mentioned, is that they were struck down 9-0 on the way that they were doing that, which was basically abusing the Younger Doctrine, which was originally set up to protect states' ability to prosecute their criminal cases, and they've been doing that to stop all kinds of much lesser cases from federal review, things that there was no clear compelling interest even for the states to be doing this. And so just in general, they've relied on the 11th Amendment, which is the sovereign immunity of the state as opposed to anything about federal programs, and they've relied also on the Younger Doctrine, which, as I said, was just struck down. Reply brief. Respondents focus only on the 11th Amendment, U.S. Constitution, to stop injunctive or declaratory relief for damages in bankruptcy, that is to say, payment of the benefits owed in monetary damages, and do not defend their Younger position. And Younger is Younger versus Harris, 401 U.S. 37, 1971, which in my case the 8th Circuit panel described as excluding federal jurisdiction when there is any supposedly parallel state civil proceeding. And the district court writes, when Carlson filed this action on February 7, 2012 as an adversary proceeding, neither Carlson 1 nor Carlson 2 was finally resolved. And neither of those are lawsuits. These were just phone conversations with unemployment law judges, ULJs. And really it was just one, but there were 2 accounts. So I called them for each account, said, I'm supposed to be able to get my federal emergency unemployment compensation benefits that I have remaining before you pay me $0 on my state account that I just established in 2010. So, that declaration that the case was not resolved, neither was resolved, is from an affidavit, actually, by the State Assistant Attorney General Scott Grosskreutz. He says Carlson does not dispute that he initiated this action in his pending bankruptcy matter prior to exhausting his state appellate remedies. And that's from the district court at page 14. Now, they do not defend their Younger Doctrine even after Sprint Communications Incorporated versus Jacobs 2013, 6 days before my petition was filed in December, because they say I don't rely on Sprint. Now, I do rely on a correct interpretation of Younger, which includes allegations that the state proceedings are in bad faith and harassment. Specifically, they are completely contrived, deception, and an outright abuse of power and unconstitutional. In addition to my questions, I do say at page 12 of the petition, quote, the Younger abstention doctrine, as applied in this case, must fall, because Minnesota has no compelling interest in depriving me or others of EUC payments when due, or of a deprivation of a hearing. Now, respondents' current position is that the Unemployment Compensation Extension Act of 2010, the Act, and the coordination provisions at 26 U.S.C. 3304 note, extending EUC benefits, does not in fact extend the federal benefits to anyone who received them in the past, and that this borders on the frivolous. While the Act was not retrospective, it surely was intended to be prospective, covering everyone who at the time of its passage, eligible for a new state account, who had remaining entitlements to be paid going forward, that they would be covered as prospective. Literally, respondents now say Congress's intent was to only allow continuing payments from a previous state benefit year where the person had qualified for emergency benefits and so had remaining entitlements but had not been paid a single dollar. What I call the coordination provisions, by the way, provide for emergency unemployment compensation as federal payments coordinated with state payments by preceding the state payments where the weekly payment would otherwise drop at least $100 a week or 25%. Respondents now admit that this was the intent of Congress for some who were eligible for a new state account. But I can't figure out who they say were supposed to be paid remaining entitlements before their state accounts. I don't think they know. Actually, I think they're saying that people who work part-time could be blocked from getting their federal unemployment compensation benefits. I did not know this because I was in a single case with a single guy on the phone. So I was not told about the full scope of this until I filed this federal case. Now they urged the court to deny the petition because the district court found I relitigated res judicata, although the 8th Circuit did not affirm on this ground. The 8th Circuit panel and my questions to the court. The per curiam of the panel, Respondent Appendix A2, touched on 3 matters in a de novo review of a motion for judgment on the pleadings. First, citing Middlesex County Ethics Commission versus Garden State Bar Association, I guess that's in New Jersey, from 1982 as, quote, extending younger and as protection of ongoing state criminal proceedings to ongoing state civil proceedings, unquote. Period. This is what the panel said in my case, period. Now in the Sprint case, they treated them better. But in this case, very important case about emergency unemployment compensation benefits, they just said, period. That all civil proceedings that there's something that they're messing around with at the state level, they can be ignored by the federal courts. And this should be struck down by the United States Supreme Court. And then the panel affirmed the dismissal of my bankruptcy adversary proceeding. That proceeding was improperly characterized as a straight civil action by the district court, and it was actually filed under 28 U.S.C. 157 and 1334. And 157 is an adversary proceeding in bankruptcy. It's not a civil proceeding. Now, as a result, the district court characterizing my bankruptcy as a way to end run or overturn supposedly still ongoing decisions as res judicata, Magistrate Keyes punished me by taking away my civil rights to access the courts, the federal courts with cases. This is not denied by respondents. The bankruptcy adversary proceedings in re Carlson, taken together, triggered the striking down of my civil rights of access to the federal courts. The deprivation of my civil rights should be stayed or reversed by this court. Since the actual deprivation of access to the courts was in 2 cases regarding my primary residence in bankruptcy, I had intended to pose a question for review to this court in that case. And that petition needs to be filed in about 10 days. Now, the Younger Doctrine was also used to deny injunctive or equitable relief or declaratory relief that respondents' action violated the Constitution, United States Constitution. And obviously it does. 2, in addition to the Younger Doctrine, the 8th Circuit panel makes no mention of constitutional requirements of the Bankruptcy Clause or the Due Process Clause or Equal Protection Clause of the 14th Amendment U.S. Constitution or the First Amendment U.S. Constitution. And this is because when this happened to me, I was the nominee for the U.S. House of Representatives from a party. And so I was never told what was going on. And so I'm raising the prospect that this was political retaliation and deterrence, in violation of the First Amendment of the United States Constitution during an election. But the 8th Circuit panel only embraces the 11th Circuit in our Constitution, recognizing no constitutional rights of EUC applicants or candidates. And 3, recognizing the standard, they also recognize the standard for denying injunctive relief as abuse of discretion, and the panel found none and upheld the denial of my motion for injunctive relief to give me my $7,000 that had been withheld, driving us, my family, into bankruptcy. Now, they did not affirm the res judicata finding, and this court should not, and should not address directly the district court's ground of res judicata to affirm the dismissal or denial as respondents urge, and should instead focus on my questions, which are compelling and represent a conflict between the circuits and between the Eighth Circuit and this court's precedents, and which do set forth and fairly include res judicata as a reason to bar federal jurisdiction as it was used in my questions 1 and 2. Now, respondents urge the court to ignore its recent decision on the Eighth Circuit's misapplication of the Younger Doctrine in Sprint, and also to ignore the issue of my entitlement to EUC payments and the violation of this court's constitutional requirements for deprivation of my continuing payments of my remaining EUC entitlements complained of in my adversary proceeding. They also argue erroneously that the district court was not exercising bankruptcy jurisdiction in my case. All of these urgings should be ignored by the court as utterly meritless. Facts. What Governor Dayton thinks. The governor, based on his submissions to this court, thinks that he and his Commissioner of Deed, Katie Sieben, substituted for Mark Phillips, have virtually unlimited power to deny emergency unemployment compensation benefits to any applicant because under his interpretation of the 11th Amendment and Younger Extension Doctrine, first, he can never be challenged, he thinks, for Deed's mishandling of federal programs and federal rights because that matter is limited to state proceedings whenever an appeal by an applicant is initiated. Secondly, he believes neither a bankruptcy court nor a federal court have the power to hold the state accountable for their administration of the program. Now, respondents maintain that what is at the heart of their refusal to grant me the rights and protections conferred on me by the 2010 Act is a legal theory that it, quote, does not apply to persons who receive federal EUC benefits before its enactment July 22, 2010, unquote. What the law actually says. Under this court's precedents, and that's Goldberg versus Kelly from 1970, Smiadak versus Family Finance Corporation, 1969, Sherbert versus Werner, 1963, Nash versus Florida Industrial Commission, 1967, and also California Department of Human Resources versus Java. That's from 1971. That involves the Social Security Act, 42 U.S.C. 503A1 and 3. And what these require is that the state of Minnesota, in order to administer this program, have to have a system of administration calculated to pay your payments and my payments when due. They did not do this for thousands of Minnesotans. So under this court's precedents and Social Security law, the respondents must comply with the federal law. The administration of the unemployment insurance program must be carried out in a way which will pay recipients when due, and deprivation of unemployment benefits, including EUC remaining entitlements when due, must be preceded by pre-deprivation due process, including notice and opportunity to be heard. A state official violating federal law can be held accountable under the 11th Amendment and this court's precedents, which I discuss in the petition at page 5. And I'm referring to Pennhurst, a state school and hospital versus Halderman, that's from 1984, noting that sovereign immunity extends to state agencies, but also cites Ex parte Young, that's from 1908, and that recognized an important exception to this general rule. That is, a suit challenging the federal constitutionality of a state official's action is not one against the state under Pennhurst, and therefore they can be held accountable for violating the federal constitution and for damages, and can be enjoined. The state can be liable for damages and can be enjoined in bankruptcy adversarial proceeding, such as this one, to turn over an account for money withheld. Younger abstention has now been limited by Sprint to equitable injunction of ongoing criminal cases in 3 more narrow categories and no further. Categories identified in New Orleans Public Service Incorporated versus Council of City of New Orleans from 1989, also called NOPSI, and it was upheld in Sprint, and the state proceedings at issue in this case do not fall within those categories. Relevant background. It is unconstitutional to deprive me of continuing EUC payments without due process first. I was deprived September 12, 2010 without notice or reason or opportunity to be heard when Dep't refused to continue payments on my remaining EUC entitlement. I asked them to pay, and they said that my only option was a phone hearing with a ULJ, unemployment law judge, which is excerpted info, and I did that. The ULJ said the case had no parties, Dep't was not a party, and you can look at the transcript, the petitioner's appendix B7 at page 12. And there he says, ULJ says, there is no other party to participate. You're the only party. Now how can such a decision be binding? Now he excluded the act, that's the Unemployment Extension Act of 2010, which I provided to him for the record and the hearing. And there was no chance to litigate anything. Definitely not constitutional issues. He had no equity authority, unlike the bankruptcy adversary proceeding. I filed under the bankruptcy's equitable jurisdiction. Now since I had worked part-time, and this is what the state appellate court said, Carlson was working part-time with earnings that exceeded the weekly benefit amount, which precluded him from receiving any benefits under the September 12, 2010 benefit account when it was established. Now that's not true. I received the benefits, but the benefit wasn't beneficial. I got 0 payments.